Dear friends and comrades, I am happy to be before you to discuss the issue of judiciary, constitution and democracy. Being employees of the government at a higher level, you are on a daily basis, you deal with the constitution, you deal with democracy, and you deal with all related issues. Before you, as persons who have experience in dealing with the service of the government, I have very little to offer to you by way of any comments. At the same time, there are certain issues which we cannot ignore today, which we can never ignore tomorrow, and therefore a conference like this or a seminar like this has to discuss certain issues which we otherwise do not discuss in our files, in our day-to-day administration. There is a complete system evolved by the British, put in place by the British for several years, and inherited by us without any question. And we try to run the government. Of late, we have been made to aware that our system cannot be secret. We cannot have the shield of Official Secrets Act. Today, it's a days of transparency. It's a days of right to service. And therefore, every participant in this scheme of government has something to play. A play which can never be treated as a trivial. A play which works with the lives of the thousands of people in this country. And therefore, you carry a very important task in this system of administration, and to have a conference and to have a seminar and to organize ourselves into an association. We also think that it is not merely our service to the government. Beyond the service to the government, we have service to the people. It is ultimately the people are our masters, and therefore our obligation, our responsibility is to the larger context of the people. It is in this sense we will have to understand what is democracy and what is constitution. I must tell you the position of government servants. I won't use the word servant, I will say employee. A government employee plays a very unique role in the constitution. Perhaps nowhere in the world there is a place for government employees in the constitution itself. Most of the constitutions in the world are only talking about division of powers between various organs of the state, and there are no provisions specifically dealing with public servants or government servants. But then we had not only spread all over, we have a separate chapter dealing with the government employees. It is in that sense our constitution is a unique constitution, but something it's not new. Even before our constitution was drafted, we had 1935 Government of India Act, which also dealt with government employees. There is a peculiar or a very significant provision which we have been borrowing not only from the 1935 Act, even from the British practice. In Britain, every employee, every public servant, he serves till the Queen or the Emperor or the King wishes them to serve. It's called doctrine of pleasure. And therefore, when the British made the Government of India Act, they also felt that a government employee serves till the Governor General wishes him to serve. It's a doctrine of pleasure which they always emphasize. It is the same doctrine of pleasure which has been incorporated in our Constitution. On the one hand, it gives the right of the employees and the right not to be dealt with arbitrarily, the right of a tenure, the right of a person to defend himself in case being charged. All this has been elaborately set out. Even a recruitment, even framing of rules, even framing of rules relating to our service condition, all that has been set out. But unfortunately, we have also inherited the British precedent that you serve till the governor's pleasure. A central government employee serves till the president's pleasure. Where do we get it? We do not know. But then ultimately, what is this pleasure doctrine? In fact, the Supreme Court once said, it is like the Henry VIII clause. The English king, eighth Henry, he can sack people, he can put people inside. It is so arbitrary. Our Supreme Court said that this pleasure doctrine cannot be expanded to the level that a person can be put today inside and tomorrow thrown outside. This is something very incongruous in a democratic system, in a republican constitution. But then we still put up with that kind of a practice. Article 311(2)(c), by which the president or the governor can throw out anybody at any time they want. How much restriction that we have put on this power. Having given an elaborate right, having given us the right of Article 311, which is considered as a charter for a government employee, we also can say, just throw them out. I was a schoolboy when 1967 elections were being held. For the first time, we realized that the Congress party, which is a monolith party, both center and state, people never imagined that party could never be removed. It was removed. In 1967, in 8 states in India, Congress party lost power. Till then, it was a monolith power. Nobody can question. Nobody can even ask a question when they were in power, because they were in power, both center and state. And 67 elections saw a small change. Even before that, Kerala had an experiment 10 years ago. In 1957, a left-front government was formed in the state, and it did not last long because the center can dismiss it. For the first time, they really saw there is an alternative power structure emerging all over India, not just south, even in some portions of the north, some portions of the east, they are emerging as an alternative political structure. A structure which is not towing the line of the center. When that came, I remember for the first time, the central government employees who are formed in a federation in all India level have placed a small charter. We are not your chattels. We are not your slaves. We need to have some minimum service condition where our salary structure, our working atmosphere should change. When the all India demand of the central government employees, the central government could not meet such a challenge, they invoked Article 311(2)(c) and removed many people from service. As a student of constitutional law, we were shocked that a government employee can be sent out without any reason because the president pleasure works there. Similarly, some of the state government employees were sent out in Tripura, in West Bengal, because they were able to participate in a mass program. They were able to organize themselves into an association and started placing demand on the government to improve their service condition. Till such time, it was never recognized that a government employee can demand certain amount of service condition which is in tune with the human rights standard. They are not slaves. They are not at the beck and call of the government all the time. And therefore, the late 60s saw the growth of the government employees in a big way, both at the all India level and also in the states where Congress party was not in power. And this was really the golden period for the government employees to come up. But they came up with a very long, tortuous path. It was not very smooth. Their history, their background, their organizational structure to come up, it was not so easy. If you see the Constitution, in 1950, when it was brought in, the 2 first challenges came. I will take you back to the history. The first challenge to the constitutional position came from no less a person than Comrade A.K. Gopalan. Comrade A.K.G. was the first man to move the court to say what kind of a constitution that you have put in. Comrade A.K.G. was in jail when there was an independence was granted to this country, when the tricolor flag was going on in red fort, and the Union Jack was brought in, and the famous speech by Pandit Jawaharlal Nehru that when the whole world is asleep, we are awake to get our freedom. This is what he said. And the flag went up, and people were really happy. But there are some people who are happy but still were in jail. And one such person was Comrade Gopalan, who was the tallest leader of the Kerala People's Movement. And he wrote from the jail. It's very important. very incongruous also, that I like this freedom. I fought for this freedom. I was jailed for 9 years for this country, but I am still inside. Then what kind of independence it is? In fact, he writes, anybody who reads this biography will know, you will shed tears, because this man says that when the night of 14th was coming down and the morning of 15th was going up, we were looking at the skies to see whether any change in the sky. And there was no sound in my jail and no other persons were around. I called all of them and tried to have a flag hoisted inside the Madras jail. He could not find out the answer. Why? That we fight for the independence. We are also working for their own victory. We have been to jail more than others, but then we are kept inside. And therefore the first question came, what is this republic that stands for? In fact, when we are drafting the new constitution, starting from 47 to 49, the 2.5 years debate, there were no communists in that house. Constituent Assembly excluded the communists. And Dr. Ambedkar, while introducing the constitution in the Constituent Assembly, the final draft, on 26 November 1949, he told the House, here is your constitution, it's for you to work or to destroy it. He also very conscious of the fact that the Constituent Assembly did not have socialists, Constituent Assembly did not have the communists inside the House. He said, the communists do not believe in democracy. He also said that socialists want all the government enterprise to be owned by the government and not by private people. And that's why they are outside. Having said that, and Dr. Ambedkar is one thing very well, during his Bombay days, he was part of the trade union movement. His own association were part of the trade union struggle. And therefore his conscience did not allow him to keep quiet. He said that we have a political freedom in this country, but we do not have an economic freedom. We do not have a social freedom. The sooner we get the social and economic freedom, it's better for this country. Otherwise, this country will go into pieces. This is what he has said. Having said that, he did not keep quiet. If you see the part 4 of the Constitution, which are not enforceable, but nevertheless, the state principles of state policy, every policy that has been incorporated only prescribe a socialist charter. Article 39 talks about that the wealth of this country cannot be monopolized in a few hands. It is not a country meant for Tatas and Birlas or Adanis or Ambanis today. That has been said in the Constitution itself. There cannot be a greater socialist charter than our own Constitution. And therefore a need has come to understand this Constitution and to uphold and to make this our charter. Because there are today attempts are made to derail, attempts are made to destroy, attempts are made to change this constitutional framework. Though we may be communists, we may be Marxists, we may not believe in this structure that has been made. We would like to work for a larger perspective for the common people. We would like to work for a larger share for the working class of this country. We would like to work for the larger share for the peasants and agricultural labor of this country. But nevertheless, we do support this constitution. That is why A.K. Gopalan did not keep quiet in the jail. He went and asked the Madras High Court, which was the High Court for the Malabar also. He said that you said that you can go around all over the country, then how is that you are putting me in Madras Central Jail? Article 19(1)(c) talks about a right for the Indian citizen to move throughout the territories of the country. If that is true, how is that I am put in jail? What is the charge against me? He was put against the Madras maintenance of public order. What is the public order that is served by keeping Gopalan inside jail? This is a question which the judges were very shocked, because for the first time they are also looking at the Constitution. For the first time lawyers are looking at it. He had a brilliant lawyer to defend him, Mr. M.K. Nambiar, who also belonged to Malabar region and whose son became the Attorney General during the last regime. Now this question is never answered by the court. The court only said there is a power to detain or you are inside. The district collector has passed an order and he has followed the procedure, therefore be inside. A.K. Gopalan was a loss in the first constitutional history. For the law students will know how our constitution was taken backwards and not forwards. And after some time he was released. That's a different issue, and he also rose to become one of the tallest leaders of the state. But the main question is, the first question in the constitution was raised by the communists, whom they said, we do not believe. We do believe. We do want to test your constitution. No, you are tested. The first two constitutional laws were filed by the communists only. Mr. Second case was a V.G. Rao case, which is very relevant for the NGOs, for the Government Officers Association, because this constitution guarantees right to form an association. Right to form an association or a society is a fundamental right in this country, and to what extent this fundamental right is allowed in this country. In fact, V.G. Rao, my senior, under whose firm I worked for several years, from whom we learned the labor laws, to whom we learned the service laws, to whom the entire country's working class is so much indebted to him. And such basis, sir, he was running a society, People's Educational Society, to impart higher knowledge to the people. That society was banned. His bank account was frozen. The first thing Congress government did was to take away your right to form an association, right to have a financial liberty to run your organization. When this ban came, not by any new law, this was the law made by the British, 1908 Criminal Law Amendment Act, which Gandhiji called it as the Rowlatt Act. The same law, they did not even have any qualms to implement this law, and V.G. Rao's association was banned, and he went to court. He did not keep quiet. He was himself a barrister. And V.G. Rao was the state of Madras, was a landmark case in the constitution, where the Madras High Court, later Supreme Court, said that the right to form an association is an integral part of the constitution. It's a fundamental right of every citizen, and no government can declare an organization an unlawful association. You cannot have a vague law. You cannot have a British tradition to ban organization. This was the first judgment which was obtained in the constitution, that too by a communist. Similar situation all over India. The trade union leaders, the leaders who were leading the government employees were inside. In Bombay, A.S.R. Chari, one of the leading lawyers, Mr. K.T. Sule, another leading lawyer, A.A.2C, both of them were detained in Bombay jail. What is the reason? Nobody knows. Maintenance of public order. What is the public order that you are talking about? Is it a graveyard silence? Is it a silence where nobody can question the ruling party? Is it a price that we pay for getting freedom? No, these are the fundamental questions that was raised in the early 50s, not by anybody else, by the communists themselves, not by anybody else, by the leaders of our own organization. They have raised the issue. In fact, if you read Chari's biography, you will know, having fought several cases all over India, the bank employees, the insurance employees, the middle class employees, all the cases were fought by Chari. And then he was inside, maintenance of public order. He did not have any book to write in the jail. He wrote to the Chief Justice, M.C. Chagla, who was one of the liberal judges in those days. He said, I have no book to read, but I want to fight this case. Please allow me to come and use your High Court library. Today they would have stopped all this. I remember when Father Stan Swami was in jail in Bombay, in the Bhime Goregaon 16 number case, nobody knew why he was inside. He's a Roman Catholic father. He was put inside. 2.5 years, no bail. 2.5 years, no charges are ever given to them. There are 16 people in India's jail. They have not even given what charge against them. Why are they inside jail? Some of them are given bail, and Father Swami was not given bail. He only asked for a sipper. You go to a fruit juice shop, you can sip fruit juice, free of cost. But then Father Swami was told, the jail rules do not provide a sipper being given to him, a straw. He was having a Parkinson's disease. He cannot hold a glass of water to drink water. The water will spill over his shirt. Therefore he said, give me a straw. That straw was denied to him. Ultimately, poor father died while he was in hospital from out of jail. Then another accused, Navulekha, another intellectual who was been well known. He asked for some books in the jail. His relatives came and gave some 24 books. 22 books were given to him. 2 books were denied. The two books that were denied was a humorous novel by P.G. Wodehouse. Some of you would have read it. In our days, when you want to see some humor, you will read Wodehouse novel. Very light reading novel. But the police said, it's inflammatory, it's incendiary. What Wodehouse novel became incendiary in this government? And that is how, when Chari and Chule asked the Chief Justice of the Bombay High Court, he was allowed to use the Bombay High Court library. Today they would have transferred the Chief Justice if he do like that. Those days they did not afraid of the government because they came in the independence tradition, and therefore they said, you come and use this. And then they used the library, they argued the case, but then they failed because the judges also had their own reservation. Today, one aspect of our topic is the judiciary. What is the role played by the judiciary in defending this constitution? It's a very important issue. In defending this democracy. Now 16 people are inside, there are no bail, there are no charges, and still they are inside. And then we are now sitting here and running a democracy, a seminar on democracy, seminar on judiciary, seminar on issues relating to judiciary, constitution, and democracy. Now this is very incongruous. A time has come we must question. There were times people were questioning all this. Today we are only listening to seminar and light reading speeches and some magazine and go away. What is the role that we play? Today what happens to them can happen to you. There is an undeclared emergency in this country where people are put behind bar for saying openly matters like this. And who are the victims for all this? Does the fundamental right enshrined in the Constitution apply to a government employee? If you look back the history, if you forget the history, if you don't even revisit our history, you will never learn anything further. Unless you learn the past, you can never go forward. Today things may be very, very good for us. Today we are in a shield. There is a left front government ruling the center, ruling the state. And therefore we have a certain amount of what is called a safety net. But how long this will go on? Where do we stand in this issue? In 1957, when EMS government was dismissed for no reason, it was dismissed. The first elected communist-supported government was dismissed. And how many protested on this? And the courts were just keeping the other side. They did not intervene. Today there could have been some possibility. In those days it was not a possibility at all. And then in 1959, I know there is a case from a railway trade union leader who was dismissed from service for no reason. They said Madras maintenance of public order. He is running a union and therefore he is dismissed. He went to the court. He asked very innocent question before the Supreme Court that why I have been dismissed. The government said you can be a union leader, you can be a government servant, but you can't have it both. That is, you can't be a union leader and a government servant. This was the position which the Supreme Court took in 1958 in Balakotaya was a Southern Railway. You must read the judgment. Either you be a union leader or you be a government servant. You can't have it both. Who gave them that power? Who gave them that kind of a very, very weird interpretation? This was the position under which government servants started fighting. Do we have a right? If you think we are part of the constitutional framework, if you think the Constitution has given a status for the government employee, then where do we stand? It took 4 years for the Supreme Court to say a government servant do have fundamental right. A government servant do have a right of expression. A government servant's right to expression cannot be taken away merely because he is a government servant. In 1962, in Kameshwar Prasad case, Supreme Court said a government servant does not lose a fundamental right merely because he entered into government service. This took 4 years. Does it mean our position has become very happy? Does it mean we give all the rights that we have today? This is the most important question that is to be posed before you, before we realize what is this constitution, what is the judiciary's attitude towards constitution. Like we have appointed in the name of the governor. You remember there was a lawyer who became a judge, who retired as the Chief Justice of the Madhya Pradesh High Court. U. Lakshman Bhatt. U. Lakshman Bhatt was a very brilliant law student. After finishing law, when the Kasaragod came to North Malabar, the part of Kerala, he started practicing in Kasaragod. And almost the workers around that place, the agricultural laborers or tenancy matters, they used to come to him. And soon he was known as a communist lawyer. Merely because you appear for left workers, merely because you appear for a Karshaka Toilali, you become branded as a communist lawyer. Later he applied for a post of a Munsif, the starting point of a judiciary. All this was in 60s. And he was given a Munsif post, not because somebody, his grandfather, his father was there. He wrote, he was selected by the High Court and the Public Service Commission, and then he became a Munsif. And while you become a Munsif, or any post in this government, or any post in the central government, there is something called police verification. Unheard of. Trying to find out which political sympathy you are having. And people like Kerala, people in West Bengal alone are treated for a double verification. If I am in Tamil Nadu, the police will come to my house and go away. If it is Kerala, not only they will come to my house, they will also go to my native village and see who he is. This double verification method was adopted by the Congress party to exclude communists from entering into government service. And Mr. U.L. Bhatt, Lakshman Bhatt, the police saying he is a communist lawyer, and the Kerala High Court terminated his service for no other reason. He came sheerly by his merit, and he was sent out merely because of the police report. Now, this is a kind of a service that we were inheriting in the initial days. In fact, I remember Justice Chennappa Reddy, who himself is a very left liberal, who strongly believed in rationalism and Marxism. He proudly said, I believe in this Marxism. When he was an Andhra Pradesh High Court judge and later became the judge of the Supreme Court, he had an occasion to deal with the spying on the government employees, the police verification system. There was an RSS school teacher in Madhya Pradesh who was denied employment because he belonged to RSS. He went to the court, and then it went to the right court, Justice Chennappa Reddy's court. And Chennappa Reddy wrote a very beautiful judgment which you should be able to read, because today in the information revolution, you need not go to a lawyer, you can see the judgment. State of Madhya Pradesh versus Raghuram Raghuvanshi, very important judgment, where Justice Chennappa Reddy traces the American position and says, in America, after the World War, all the communists were weeded out from the government service, because there was a Secretary of State by name McCarthy, and it is called McCarthyism. If you are a communist, you will be sent out, and they will give a form. You will have to fill up the form. Are you a member of any sectarian or a political party? If you say yes, you will send out. If you say no, on verification you will be sent out. If you simply put a dash that you are trying to deny something, therefore you are sent out. Hundreds and thousands of communists were sent out of public service in America. And Justice Chennappa Reddy wrote that McCarthyism has no place in the Indian Constitution. This is the most important issue. That we do not hound out people on the basis of the political faith. After entering into government service, you may put some service condition, you must put some conduct rules, but not before entering into service. But you must know one thing, even today in Kerala and West Bengal, this double verification continues. That is a state of government which Congress gave it to the BJP, and BJP vigorously pursuing these matters. Notwithstanding a judgment by the court, the court says McCarthyism has no place in the Indian Constitution. Recently you will find that two judges from Madras High Court and Bombay High Court, they were elevated to the Supreme Court. The Madras Collegium agreed. The Supreme Court Collegium agreed. One person name is John Satyam. John Satyam wrote in the Facebook some criticism of Modi. Modi is not God. Modi is not omnipresent. Modi is an elected leader. He can be criticized. As many followers he has got, as many critics also he can have. He only said in the first book that some matters he put that. Then the Indian Intelligence Bureau writes a letter, this John Sathyan is anti-Modi. There is another judge in Bombay High Court, Somasekhar. His name was sent. He was also there in the Facebook, social media is there, everybody is there. You want to pass time, you are there in the media, and you may put, or you may put like, or you may even share. By sharing, what do you get? By criticizing Modi, what do you get? Can't you become a leader of this country? Can't you become, if you can become a leader of the country, you can also become a judge of this High Court. And now John Satyam and Somasekhar was denied judgeship. The Supreme Court Collegium was very embarrassed because the name which they strongly recommended, there are no adverse. They are good lawyers. They have a good practice. They have a good earning. And there are better statements made about them. And therefore they agree. And now the Intelligence Bureau, which is a watchdog of the Modi government, says no, they can't become a judge. And now the Supreme Court take pains to point out, we do not agree with you, please make them judge. They will not make them a judge for the simple reason they are critique of the Prime Minister. This is a system we have. Don't think some NGO, some government official or a group one office. Even for a High Court judge, your political perceptions are watched in this country. Your political attitudes are watched. And then the government says we will not make him a judge. Till date, they have not been made a judge. Very recently, the Chief Justice of India, Justice Dhananjay Chandrachud, wrote that the political fight cannot be a parameter for deciding whether somebody should enter into the government service or not. We are not agreeing with the central government perception on this issue. Please make them a judge. They have not been made a judge. More than 1 year has gone. Somasekhar not appointed. John Satyam not appointed. But then how do you see this issue? There is another girl from Kanyakumari, your neighboring, next to Travancore. She is an All India President of BJP Mahila Samiti. Her name is recommended. Next day she is appointed. Some people question, how do you appoint somebody who is a political party leader? They say that's not a prohibition. If what is not prohibition for Victoria Gowri is a prohibition for John Satyam, is a prohibition for Somasekhar. Now where do you go from here? Do you think the higher judiciary is appointed free of any political consideration? And you are discussing about judiciary and constitution. It is this judiciary which is going to interpret this constitution. And therefore it is important that who adorns the judiciary. Victoria Gowris can become judges in this country, but not John Satyam, not Somasekhar. There is also another ridiculous thing. There is a Delhi High Court judge. The only crime was he married a foreign wife. And his sexual preference was different. And then they write to the RAW. RAW is a political espionage wing of the central government. It has got nothing to do with our domestic affair. But then the RAW gives a report, this man marries a foreign woman. How is it wrong? Your own foreign secretary marries a foreign woman only. Mr. Jaishankar's wife, you ask which foreign country she belongs to. And now that becomes a disqualification. Not only that is a disqualification, even his sexual preference. Why do the police enter into my bedroom and see what I am doing? Now that becomes a disqualification because you are all morals that you have is a 19th century British morals that you are holding this. And now that man is not appointed. Who is appointed and who is not appointed is an issue that you will have to consider. It is not our job to go to the office and come back 9 to 5 our work. The rest of it we spend our time with our family. Today time has come when we got to participate in every system of nation building. Who adorns this judiciary? Who is going to decide my future? Who is going to decide my future? You must say one thing. Constitution has got 395 sections in this 395 articles. There are so many subclauses. There are some schedules are there attached to the Constitution. On the whole, you may have some 500 provisions in the whole. But it is not what the Constitution says. It is what the judges say. Every statement they make becomes the law of this country. And therefore, it is important for me to see who is my judge. Who is going to be my judge. It is not something we are totally unconnected with. Every issue we will have to start discussing. Because if you do not discuss, it is a benefit for them. It is in that sense, when the Constitution talked about pleasure, it also said there shall be a governor of a state. Kerala has got a governor. Tamil Nadu has got a governor. There are governors in every state also. Even Union Territory has got a lieutenant governor. That is not important. But Governor Arif Mohammad Khan, Governor T.N. Ravi becomes important because what they do is within the Constitution or outside the Constitution. In fact, once Arif Mohammad said, I can dismiss anybody I want. They are working under my pleasure. Little he realizes that he doesn't have any pleasure. Every action of his is controlled by the Council of Ministers headed by a Chief Minister. It's a democracy. In this democracy, the powers are shared between different organs of the state and spelled out specifically in the Constitution itself. Nobody can assume power. Nobody is a Maharaja. Nobody is a king. But then Arif Muhammad Khan thinks he is a king. Ravi thinks he is a king. Tamilisai Soundarajan Telangana thinks she is a queen in that state. And therefore, we are going through a new process. A governor says you are acting under my pleasure, all right. You are acting under the pleasure of the President of India. And President of India doesn't have any power. It's a Modi Shah which operates the President. And now you are saying that the government servant I can dismiss anybody I want. No, you must learn the constitutional law. You can't send people to destabilize a state. Today the post of governor is completely being misused by the Home Ministry, by the BJP party, and then sending people to try to say several things. In fact, not only they trying to delay bills, trying to interfere with the educational institution, but they are also giving talks everywhere, the pep talks. Governors are usually invited, some sari shop, some jewelry shop. Now today they go and lecture to students, all India service students. And our governor, Mr. Ravi, who is an ex-IPS officer, I don't know whether he read the Constitution or not, he has not, his understanding can be revealed from the public statement. He said that the India is today destroyed because of Karl Marx. We were shocked. What has Karl Marx got to do with the India? I don't understand. According to them, Marxism destroyed this country. Then what is the alternative? We should have Sanadana. Sanadana is the greatest contribution that you make to this country. That's what he said. Now what is this, all this argument? Sitting in a governor post, sitting in Rajbhavan, you start saying all this. In fact, 2 days before he was taking class for the All India Service candidate who was to become IAS and IPS. He told the students that when a bill comes to me and then I sit over it, the very fact that it is delayed, it dies by itself. And the next day, Tamil Nadu Assembly passed a censure motion. Never heard of. There shall be a governor of a state in each state, and he is the head of the state. And the Assembly passes a resolution condemning the governor. The same afternoon, he gives assent to the bill. Does it mean you understand only that language and not any other pure and civilized language of law and rule of law? How is that we are having a new specimen like the new governors that we have? Does he not think they are not acting as individuals, they are acting like a pattern? A pattern by which an elected state government is put to embarrassment. The elected state government, which is also responsible to the people, are tested by unelected appointee governor. Your tenure is only the tenure till Modi Shah wants you to be there. And you now try to tell people that you are working under my pleasure. It is this issue the government employees must think. Don't ever think that you are working under the governor. You are working under a governor of a state who is bound by the advice given by the Council of Ministers led by the Chief Minister. Now that is how you work. Otherwise you have no power. You are simply a tire without air. And now you are trying to boast yourself as if you are a reincarnation. As if you are a reincarnation of a Raj Pramukh. Before that governors were called as Raj Pramukh. And before that they were called as the Queen of England. You are not having any such powers. Even in those countries, they made a democracy more responsible to the people's desire and not a monarchy. And now people now try to take us back to the monarchical days. And this is something which we'll have to think. There is another question which comes. Where do we stand? Every initial, every note that you put up goes till the end. If you are honest and you have a perspective, your note must play till the end of the file that sees through the final government order. But then we start thinking in a different way. We also do not think that we are servants of the people. All of us have some Arif Muhammad Khan syndrome in our blood. So when people come to us, we do not attend to their problem. We are not transparent. You must also know, today the days of Right to Information Act, right of transparency, people have also demanding today the right to service. You may think it's a greater work for you, there is a greater strain for you. Ultimately, who are you serving? Are you serving the common man? Or just as Krishna here calls, Daritra Narayana? Are the Daritra Narayana our constituency? Or Arif Muhammad Khan is our constituency? You know, in Madras, Tamil Nadu, we had Jayalalitha's government. You must have read some 12 years back. In 2002, she simply dismissed 200,000 government employees. 200,000 in one day, one stroke. Then only people realize there is a government service means for all time to come. My own generation, next generation will come. There is nothing like a government service. She made people to realize there is nothing like that. If I want, all of you are out. Unfortunately, I had the opportunity of arguing that case before the Madras High Court and Supreme Court. And then in Madras High Court, when the case was going on, there were hundreds of thousands of employees were there in the court compound. It's a huge campus. And largely women employees who are also dependent upon the employment. And they were crying. They were sad. And we did not know what to do. We were arguing the case for 7 days continuously. Morning and evening we were arguing. On the 7th day, when the judgment was pronounced at 9 o'clock in the night, they dismissed all the cases. Madras High Court dismissed. And you could see the women employees crying, men employees were sad because 200,000 employees in street never heard of, never in the history of the India, never in a constitutional democracy. And then the press came to me and said, what is that you are going to do? I said, we are going to Supreme Court. We always say, we lose this case, we go to Supreme Court. I also went to my house saying Supreme Court. Everybody said, the lawyer said we are going to Supreme Court. First day, second day, third day, nobody came to Supreme Court. There was not a single government employee who was willing to go to Supreme Court. Notwithstanding, in fact, they have lost the employment. Not 1 or 2, but 200,000. Finally, Mr. T.K. Rangarajan, a member of parliament of the CPIM party in Rajya Sabha, he came to lend his name. We filed the case in the name of T.K. Rangarajan, who is not a government employee, neither in central government nor in state government nor an ex-employee. He was a private sector employee. He was working in a sugarcane company, that's all. He was a CITU leader. So he filed the case. The judges asked in Supreme Court, who is this T.K. Rangarajan you are filing? And which government service he belonged to? Sir, nobody in Tamil Nadu is willing to argue this case. Therefore, we have filed in the name. They said, we cannot believe that out of 800,000 employees in the state, not one employee is willing to lend his name. That was a fear psychosis. That was a system in which we have been reduced to. We had a powerful association. As powerful as your association. But when it comes to attack, when it comes to losing employment, when it comes to a fearful dictator, people just crumble. This is the kind of a strength that we have built in our mind. This is a kind of a determination that we have built over the years, and not one person. Finally, Supreme Court entertained, and most of the employees got back, and there was a change of government. They also got back arrears of salary. Everything came through. But one thing, in T.K. Rangarajan was the state of Tamil Nadu. The Supreme Court made most nastiest comment that they made, that the government employees cannot go on strike. Now what is that we are talking about? You give away something and lose heavily. You have no right to form an association. Now you can form an association, at the same time you cannot be in politics. Now you can demonstrate, but you cannot have strike to work. So Kameshwar Prasad to T.K. Rangarajan, what we gained, we have also lost. Today, when we want to say something, when we want our demand to be met, what is that we have? I remember one American public sector association president said, of late, we are not having any collective bargaining, we are only having collective begging. Now, this is a standard that we have reduced to. What we call as a pillar, as a steel frame of India, as a steel frame of bureaucracy, today we are reduced to some begging. Just give this, give that. Therefore, a time has come. We'll have to redeem ourselves of our original power, of our constitutional position, and our united power to stand against any oppressive government. A government which can never defeat us. A government which can never tell us to go away. And it is in that sense, when you talk about judiciary, when you talk about constitution, when you talk about democracy, you must know one thing. We are the pillars of democracy. It is because of us the wheels are moving. It is because of us there is dynamism in the society. It is because of me the state moved forward. It is in that sense that we should understand the Constitution in a wider context. We should also have a judiciary which will be amenable, which will be responsible to the needs of the people. We will also have a democracy which will sustain our movement to further, which will sustain this country further. Because there are words, there are echoes, there are sounds to remove the democracy. One match, one nation, and one language, and one food, and everything is one only. And who is that one? You know. Time has come. It is not just only in the government offices. It is not only in taluk offices. It is in our polling booth. We will have to tell them, this democracy will sustain. This democratic republic will sustain. This will have socialism and secularism as watchword. And this we will never allow this sovereign country to go away in a different direction. And we will show our might and strength to these people who try to decry this constitution. Thank you.